session. Now, with J.E. Cohen, the judge, all persons having business for this court draw near, give attention, you shall be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good morning. Welcome to an oral argument session, 5th District Court of Appeal. As you have heard, my name is Jay Cohen. To my right, Carrie Evander, Bruce Jacobus, both from Brevard County, also joining me on the panel today. If anyone has any electronic devices, phones, beepers, anything of that nature, if you would please turn them off so that it does not disrupt the flow of argument. We have at least 2, perhaps 3 cases that we're going to have oral argument on this morning. All 3 are civil cases. The parties will be allotted 20 minutes each for argument. If the appellant would like rebuttal argument, please advise me at the beginning of the argument as to how much time you would like to reserve for rebuttal. The first case that we're going to call on this morning's docket is CISSEL versus TEATE. I'm not sure that I'm pronouncing that correctly. The appellee has not filed a brief in this case, therefore, obviously there will be no rebuttal argument because the appellee will not be allowed any argument. Okay, counsel, are you ready?
Yes, sir.
All right.
Yes, Your Honor. Good morning, Your Honors. May it please the Court. My name is Stephen CISSEL. I am the appellant and I'm pro se. The reason we're here today in this appeal is that the findings of the General Magistrate were not consistent in the award of alimony, and the alimony is excessive. It's not consistent with the record, the competent evidence of the record. The evidence of the record was put into the record during trial, unrebutted by the former wife, and there was equal opportunities for the General Magistrate.
Let me ask you about the unrebutted. Do you understand that the magistrate was not required to believe everything you said?
Yes, sir, I do understand that.
All right, and you had the burden because all the financial information was in your possession, no one else's.
Yes, sir, I have the burden. And
the magistrate made findings that your testimony on what you did in the past had a lot of inconsistencies and flaws in it. For instance, saying, one year that indicating at $36,000 or so of income, and yet you were able to pay alimony and child support the amount of $30,000. The magistrate apparently didn't think that made a lot of sense. Now, so, do you understand that the magistrate has the right to disregard some of your testimony if it seems to have some giant question marks on it?
Yes, sir, I do understand that.
And you understand that we can correct errors of law, but we can't correct errors if the magistrate chose to believe someone and not someone else, or chose to reject some testimony if there's reason to it, even if we would not have rejected it.
But if she finds something that is not true, if her findings lead to something, to make something out of something that's just not true, then we should address that. And that's what I'm here for. Because during that specific part of her findings, she doesn't address the savings that I had at that time. She doesn't address the assets that I had at that time to sell, to pay those amounts of alimony during those lean years. And that was addressed in trial. The evidence was presented to her and brought evidence in with not only the evidence I gave, but brought in competent expert evidence, testimony by a certified public accountant. I refer to the record that the First Star bank statements were entered into record volume 1, page 190 through 208. And they were verified in court during trial by a certified public accountant, and that's record volume 3, page 332, lines 16 through 24, where he establishes the accuracy of the records that I've submitted into evidence.
Let me ask you this. Is it your position that the alimony award could not have been in excess of $800?
In my opinion, this alimony award should have been over 27% of the actual income that I was establishing at the time, that it should be closer to $350 or $400 maximum. That's my assertion, is because the evidence in the record, in record volume 2, page 273, where she cites, in Record Volume 2, page 273, she cites an amount of income that's not true.
Well, part of the income, I think, is that you were paying some personal expenses out of the business.
Yeah, but I submitted every bank statement I had. I submitted all of my records, all of them. My personal bank statements show my expenses that I have. And they tie to my income. I showed my bank records for my corporation, and they tie to the expenses. And I brought in a public accountant that's got his record on stake to qualify himself as an expert witness and to put his risk of perjury on court, testifies that my record keeping is accurate and true. And I testified in court, and it was exposed to the general magistrate that he pertained to many audits with me with the IRS.
Well, you convinced the magistrate that you had a substantial change of circumstances, and so the magistrate ruled in your favor. The only thing that the magistrate apparently has done that you don't like is to set the award of alimony at $1,000 instead of, which was half of what it had been. So you were given a significant reduction in the amount of alimony, but didn't submit it or did not set it lower than that. And that's your primary objection on appeal, correct?
Well, that's part of my objection on appeal. You're correct, except for this. During the hearing on exceptions on January 12th, Judge Alexander says, well, she already reduced it by 2/3. And I said, no, sir, she had not. So obviously he might have recognized some of the records and reviewed them, because his challenge is to review it carefully. But I also complained during that hearing that the record wasn't complete, that the evidence that I had submitted to her in trial on October 5th, and now we're in a hearing 98 days later, and it's not in the record yet, it's not in the docket, and so I had to argue my case based on the transcripts, which I attempted to do, where I said, Your Honor, in transcript such and such, this evidence was entered into it. So even if his 2/3, he would have been closer to the hearing.
Had you paid for the transcription of the hearing in front of the hearing officer?
Yes, sir, I did.
Okay. What did that cost?
I'd have to go back and look at that record, but usually it's about $100, depending on the length of the pages that they do. And I don't remember that exactly, but the hearing officers was probably several $100s by the time I got through to it, but plus the cost of the hearing officer or the recorder in the court. But without the hearing, without the transcripts, I wouldn't even be standing here today. I had to file a supplemental motion in this court to make sure that to get an extension of time, because it took 127 days from the date of the hearing to get that evidence, that crucial October 5th evidence, where I bring in openly my pay stubs, my actual pay stubs I bring in. I bring in my personal banking records. I bring in my updated financial records for my company and all the bank statements. Every check I've written, every deposit I've made, they all tie together. And I brought them in as an updated function in the rebuttal.
But you understand that if the hearing officer makes a finding that you're paying expenses, personal expenses out of your corporation, that can be included in your income.
Yes, sir, I do understand that, and they're disclosed in my financial affidavit.
It was your car and your health insurance or one, right? You paid for your car expenses, health insurance?
I get a 1099 on my car expenses because the company owns the car. It covers the company pays all the gas and the expenses. I get charged a 1099 for the use of that car. Just like and of course my health insurance is paid through the company, but I get charged for that as well.
Let me ask you this. What did the record reflect as far as how much you were contributing to your adult child support?
The record, I'm not contributing. My contributions to my adult child support ended in May when she turned 18.
No, but
I had a $37 expense for her health insurance, part of my health plan. Obviously, I'm fighting a tremendous battle.
Is there anything else?
Sir?
Is there anything else that you were doing to help her?
Only thing I can know, no, there's the incidental stuff, the very, very small things at all for my child that's going to college and things like that. I didn't...
Were you assisting her with payment of tuition?
No, so she has a Florida prepaid that we paid for when she was in first grade.
Right.
And, but no, there's no... honestly, I brought forth every ounce of evidence. I knew this was a hotly contested divorce. This is a marital business that was hotly contested at the time of the final judgment, and that's in our record. Even this district heard that appeal in CISSEL versus CISSEL, and it's a hotly contested thing. I knew I would have to have all my records in order. Listen, I fought with the IRS for 5 years trying to restructure the marital records because they were secreted from me during the divorce. When this incident went down, when this separation went down through a domestic violence act, I filed a restraining order.
We're here about the order on alimony.
I know we are, but remember, we're here also about the alimony, but also about the IRS marital debt.
Well, no, actually, we aren't here about the marital debt. You've put that in your brief, but in looking over your petition that you filed, the relief that you sought was the former husband therefore requests this court terminate, reduce, or abate my alimony obligation and terminate my child support obligation. So your petition that you filed, the former husband's verified supplemental petition for modification in alimony and child support, and or motion to temporarily abate alimony due to change in financial conditions, that was the relief that you sought. And so that was the relief that the lower court ruled upon, and we are now not going to go back and look at the IRS debt from the time of the dissolution of marriage. You didn't file a petition, reference it, it's not legitimately part of this appeal. So what we're going to look at is the reduction of alimony.
Well, I made an error then, and I will readdress that in a future, but I can share with you this, that this is a situation that's been very strenuous, and there's an absolute ruling in this court, in the lower court's findings, that there was an involuntary reduction in alimony.
Please don't take anything that I said as any indication that the lower court would have authority to do anything about that past debt. I'm not insinuating that in any fashion. All I'm doing is trying to set for you the parameters of this appeal.
Well, like I said, my initial brief was written with that in it as a point.
We can't consider something that you didn't request and that the lower court didn't consider. Okay, so that's what Judge Cohen's telling you. So we can't even consider it, regardless of whether you're right, wrong, indifferent.
Well, let's talk about the evidence and the quality of the substantial competent evidence that was entered into court and the testimony that was brought. There was a tremendous amount of testimony about allegations, accusations, and things that were all rebutted by expert witnesses, by witnesses in my partnerships. I brought in the witnesses to testify that I am who I say I am, that I am a project manager that does work, and that I've had a significant reduction in my income and a significant change in circumstances that were involuntary. I would hope you'd reverse the order of contempt, because I wasn't in contempt. I couldn't afford to pay it. And even alimony as it's assigned based on the facts, the evidence.
Well, there was no purge amount. You weren't incarcerated. There was no purge amount. I think that the finding was that you had been paying $200 in alimony and that you had the ability at that time to have paid more than that. Obviously, the trial court awarded $1,000 in ongoing alimony, and so those two really tie in together.
And those are excessive. The $1,000 is excessive. It's over 69% of my actual income. And the income that I have is accurate and true, and that's what's in the evidence. And that evidence was authenticated by an expert witness that came in and testified, and I'm here to plead with this court, this panel, to understand that if I go through the process, I'm living way below the national standard of living today. I've lowered all my income. I've done everything I can do. She found me. There wasn't a purge amount for incarceration during the trial, but there was one forthcoming later. There has been since. And I still have suffered tremendously with the burden of having to pay. It exceeds my income. I do without a lot of things. I don't have a lawyer. I can't afford a lawyer to handle this representation. I've had to go through this process as a pro se litigant based on my First Amendment rights. And I've been trying as hard as I can, doing the best job I can, to put together the facts, to educate the court as to what the real situation is. Everything that I've said and put into the trial court was unrebutted. The former wife didn't even cross-examine the CPA that was there, that testified. I had a record of doing my accounts for 10 years. He testified to my credibility. he testified to what I was saying was the truth and accuracy. He had tremendous experience with me through the IRS and represented me. I'm an honest person. I represented myself honestly. Even the witnesses I deposed and came in and testified were my partners, and they validated the fact there was a significant change in circumstances. They validated the fact that I was a credible person.
Let me ask you this. I know your testimony was that you can't make it on $1,000 a month alimony. Was your former wife's testimony that she couldn't make it without the alimony?
And when you read her testimony...
I'm just asking you yes or no.
Her testimony was all over the board. Her testimony centered on the fact that she had no job, she had no income. When I went to get her when I filed a proper notice to produce, to rebut her testimony, she refused to it. During the course of the trial, remember the first hearing was on the 21st of July, the second hearing was on August 26th, and the final hearing was on October 5th. During that hiatus, I was able to file a notice to produce. She was able to file a refusal to produce. I was able to get a hearing in front of the judge. He ordered her to produce. She still failed to produce. And to produce a trial. I finally got her my exhibit number 10, were 2008 and 2009 income tax statements. She wouldn't put her bank statements in, any of the other facts that she did testify she had a living boyfriend. She did testify she had received loans from undisclosed men. She did disclose this in her testimony, that she had loans from people, that she was getting support from outside people. So she refused, but if you read her tax returns, and if you look at my brief on her tax returns, you'll see she's writing off a $32,000 home office expense. She has income coming in. She drives a Mercedes. She lives in $1.5 million home. I'm living in a 400 square foot efficiency apartment in the bad blighted section of Jacksonville, Florida, because I'm trying to resemble...
But she's living in a home that she's the sales manager for, and she gets to live there until it's sold, right?
She's a home manager. She has
she's not the owner of the home. I mean, she's
not the owner of the home, but she lives in the home for barters for income. And established during trial, that income was probably close to $3,000 a month, bartered income that she was getting, because bartered income is legitimately part of it. It was interesting, the general magistrate writes in her findings, well, they both had bartered income because
when the house is sold, she's not living in $1 million home.
She has a group of homes that she manages in her home management program. She furnishes a group of homes. She said in her court testimony, said she even trains the other managers that live in the homes. She has a very active business. Still today, she has an active business.
And you get to live in a home that you don't pay for.
Let's get clear on the home I live in. It's 400 square feet. It's an efficiency. I live in the same, my bedroom, I sleep next to my refrigerator. So I wouldn't consider it a home that I would consider anything close to what the marital lifestyle was. I've had to reduce my lifestyle tremendously in order to maintain a company, because I found out during this economic recession it's impossible for me to get a job in corporate America. I have tried. My testimony in the lower court since this time period over hearings of contempt, and I have had a hearing of contempt denied now on December 1st of 2011. The judge denied the motion of contempt because he knew I was good in putting forth good faith. He had seen the lease agreement that she had with her live-in boyfriend that was paying her $500 a month that has never shown up on one of her financial affidavits. So I have reduced my lifestyle. I live in a rough section, but I tell you one thing, it's very important because it affords me the ability to keep my insurances paid, to keep my company active, to at least I have a company. And that company operates on about $2,000 to $2,500 a month, which is down, it used to, during 2007 and 2008. And if you look at my tax returns, if you see the First Star Development, you'll see I had an office, a nice office. I had employees. I was paying $4,000 a month back in those days when I had revenues coming in, but there are no more revenues coming in right now. This is a serious recession in this country, in this state specifically, and in my industry, it's a depression. And I have fought, I've tried as hard as I can, but corporate America doesn't need a 63-year-old guy. The only reason I have any money at all to even be here today and to pay for the gas, to come down here to do this trial, is because I get a Social Security check every month. My Social Security check is the only way I've been able to pay anything towards my alimony. I started receiving that Social Security check in February of 2011. And it's the only thing that sustained me because the company does not make enough money. Even in my September records of the financial statements for my company, it was losing $3,500 so far that year. Now granted, inside of that, there's some 1099 income that some benefits me. My car insurance, being able to drive the car, okay, that's a benefit. Help paying my health insurance, that's a cash flow in the health insurance, that's a benefit. But I end up paying taxes on that. So I'm just here to plead with this court to reverse and remand this matter back to the lower trial court for further proceedings, to abate the award of alimony. It should have been abated completely based on the facts, based on the evidence in the record. And I understand the presumptions of the general magistrate when there's a few previous hearings on contempt. I really do. I understand the factors of credibility. I've been told this to do.
You know, if the magistrate made the same findings as the magistrate made before on your income and added the Social Security, your obligation might actually go up. So
actually, the Social Security came in after trial. So during trial is what we're talking about.
I know, but if this went back to court and you started from scratch, your obligation might be higher.
It might be higher, and if that if you reverse it, that'll be coming back when we go to the lower court and we retry this thing. But it'll be predicated on the value of the 1099 income coming from the company, and it'll be valued based on those facts that day, just like it was the last time it came out of the appellate process. Anyway, back to what I really want you to do. You should abate it completely, but if you can't, you should lower it to $395.45, which is 27% of the evidence. And that evidence should prevail. And the testimony that's credible, authenticated, and certified in court by certified witnesses, qualified witnesses, should be something I'd like to believe that the court has the ability to do, to recognize those facts.
All right, thank you, Mr. Silver. All right,